Everybody say, say, how can I express my gratitude for all the many things you've done for me? Words are not enough, to say thank you. Say, Lord, you are my everything. You're my everything. How can I express my gratitude? How can I express my gratitude for all the many things, Father, you done for me, yeah. Words are not enough to say thank you. So Lord, you are, you're my everything. Say, I call you Jireh. Lord, my provider. I call you Nisi. You are my battle. I call you Rapha. Hey. You are my healer. Say, Lord, you are. You're my everything. I call you Jireh. Lord, my provider. I call you Nisi. You are my battle. I call you Rapha. You are my healer. Say, Lord, you are. You're my everything. Uya matinyana. Uya matinyana. Uya matinyana. Oh, uya matinyana. Yeah, so uya. Uya matinyana. Uya matinyana.
A lovely afternoon to you. It's a Saturday afternoon once again, and we're live on the Community and the Law and on BW TV. We're coming your way courtesy BWF Solicitors. My name is Oreku Frimpon. Today is a Saturday, the 20th of April, 2024. Now, your child was born abroad and still living abroad. How do you successfully register this child to become a British citizen? This and many updates coming up on the program, The Community and the Law, right live on BW TV.
Hello. Yeah, you're good. Hello. There are several questions in the community when it comes to the law, especially with immigration matters. That is why I'm inviting you to join us on the program, The Community and the Law, live on BW TV and brought to you by BWF Solicitors, our trusted partners when it comes to the law. We are going to have a very massive discussion on some of the issues of immigration matters that bother you. And they have the opportunity to meet you live on the program to explain to you all the updates that have come from the Home Office and also address your questions and concerns that you might have when it comes to the law. The Community and the Law is brought to you every Saturday between 4 p.m. and 6 p.m. UK time. We're live on all social media platforms, YouTube, Facebook, and LinkedIn. At BWF Solicitors, at BW TV, and of course, we urge you to share the program and invite others to join us. Remember, it's at 4 p.m. to 6 p.m. every Saturday, live on BW TV. You have your questions. There are answers. So join us, learn, and empower yourself on the program, The Community and the Law. So pick up the phone and dial 0208 493 7345. Or you can send a text 07950 422 780. It's The Community and the Law. My name is Oreku Frimpon, and I am your host.
Based in London, we are a dynamic award-winning firm specializing in a range of legal services. Welcome to BWF Solicitors, a trusted and experienced law firm specialising in immigration and nationality, appeals and judicial review, dispute resolution, family and matrimonial, and other family law disputes with international context. These include matters such as private child arrangement orders, contested and uncontested divorce, non-molestation for domestic violence, and financial remedy. Our childcare and family team appreciate the issues facing you at such a difficult time. Our advice is delivered in a confidential and sensitive manner. Meet Bernard Owusu, our esteemed senior partner, with over 32 years of experience and known for his expertise and dedication to serving our clients and the community. BWF Solicitors stands for integrity, respect, excellence, teamwork, diversity, inclusion, and service to the community. We provide tailored assistance specific to your case. At BWF Solicitors, every day is filled with dedication, creativity, and a commitment to finding the best solutions for our clients. Our team at BWF Solicitors is ready to assist you with all your legal needs. You can find us at the 4th floor, Anna House, 214 to 218 High Road, Seven Sisters, London, N15 4NP. Our main office line is 0208 493 7340, or our emergency line is 07712 761 884.
When you've got Akasi Pong, Minister OJ, Alexa Champong, and Diana Hamilton, what have you got? It can only be the return of Emmanuel Praise, brought to you by Alexa Champong Ministries. On Sunday, 26th of May, at the Pavilion, 143 to 145 Oxford Road, Reading, RG1 7UY. Doors open at 5. Tickets are £30 standard, £50 VIP, which includes your VIP seat, meet and greet and take pictures with artists, VIP snacks, water and drink, and an under 18 concession rate of £15. Get yours at alexchampong.com or call +44 744 741 7321. Emmanuel Praise with Minister OJ, Akasi Pong, Diana Hamilton, and Alexa Champong. You will be blessed.
Hello, lovely people. It's another wonderful Saturday afternoon here with us in the United Kingdom, and by courtesy of BWF Solicitors, we're live on BW TV, bringing you the community and the law, the program that helps you to understand all the issues of law here in the UK, immigration issues as they do affect you, and the rest of it. Our trusted partners when it comes to the law is BWF Solicitors, located on the 4th floor of the Anna House, 214 to 218 Tottenham High Road, Seven Sisters, North London. They work Monday to Fridays between 9:30 in the morning and 6 p.m. in the evening. Now, what do? They help you to understand the law. They help you put your applications for all your immigration matters. If there are appeals and other objections that you want to raise to anything when it comes to the law, BWF Solicitors does it so very well. They advise you on family matters, marriages, divorces, and what you can do with those situations. And of course, with business activities that would help you bring in workers from outside of the UK to help your business here in the UK. BWF Solicitors, you can call them on 0208 493 7340. 0208 493 7340. Or if you are outside of the UK and in Ghana especially, you can call them on 00233 55 589 5959. 00233, that is international code, 55 589 5959. Or in emergency situations, you can call the number 004477 12761884. You can find all these numbers at the bottom of your screen at the moment. Now, this afternoon, what do I have up my sleeves for you? You have your child born abroad of the UK, and you would want to help your child maintain his or her British citizenship. How do you successfully register this child to become a British citizen, as I mentioned? Lawyer Charles Asma, well, his seat is empty. I'm getting him ready to sit in. He will be helping us to have that discussion. He'll be telling us what steps to take, how we go about all these things and the rest of it. So you would have to stay with us and get that knowledge up your sleeves as well. And then later on, we will have the chance of asking him several of our questions that bother our mind when it comes to immigration matters and law issues here in the UK. Now, as I do on the program, whatever updates there are, I'll be taking you through them. So we'll be going through our nuggets that was brought onto our social media platforms earlier in the week. We'll have a discussion and an explanation of that. Then we will also have the opportunity of testing ourselves to see whether we have really learned what updates there are or what situation that is that we talk about. So all these on the program, the community and the law is a package you would want to really have an advantage of. So ask your friend to ask the other friend to ask a brother and a sister and everybody in the family to say that, yes, we are live on BW TV. We're bringing you the community and the law. And of course, there is a lot to learn. So like the page, click on the notification button so that when we put any content on the platform, you'll be notified about that, you don't miss anything. Then again, you share the link so others will come join us on this very wonderful journey we're going to have between now and 6 p.m. 2 solid hours of knowledge, excitement, and of course, empowerment. Once again, my name is Oreku Frimpong, and I would want to say thank you once again to BWF Solicitors. And when we come back, I'll be giving you the updates. Stick and stay.
Based in London, we are a dynamic award-winning firm specialising in a range of legal services. Welcome to BWF Solicitors, a trusted and experienced law firm specialising in immigration and nationality, appeals and judicial review, dispute resolution, family and matrimonial, and other family law disputes with international context. These include matters such as private child arrangement orders, contested and uncontested divorce, non-molestation for domestic violence, and financial remedy. Our childcare and family team appreciate the issues facing you at such a difficult time. Our advice is delivered in a confidential and sensitive manner. Meet Bernard Owusu, our esteemed senior partner. With over 32 years of experience and known for his expertise and dedication to serving our clients and the community. BWF Solicitors stands for integrity, respect, excellence, teamwork, diversity, inclusion, and service to the community. We provide tailored assistance specific to your case. At BWF Solicitors, every day is filled with dedication, creativity, and a commitment to finding the best solutions for our clients. Our team at BWF Solicitors is ready to assist you with all your legal needs. You can find us at the 4th floor, Anna House, 214 to 218 High Road, Seven Sisters, London, N15 4NP. Our main office line is 0208 493 7340 or our emergency line is 07712 761 884.
Welcome back and thank you very much. I know you all appreciate BWF solicitors as it is that they bring us the community and the law. Now let's look at what the nugget we have for this week. I'll be actually taking you through that quickly. Under Section 98 of the Employment Rights Act of 1996, if an employee is dismissed, the employer must put forward a potentially fair reason for the dismissal. Otherwise, the dismissal will be unfair. It goes on to say that in order for a dismissal to be substantively fair, it must fall within the range of reasonable responses in the circumstances. This means that the dismissal of the employee must be reasonable. The evaluation of its reasonableness also depends on some three factors. One, whether a fair investigation has been carried out. Two, whether the respondent had an honest belief that the allegations made were true. Three, whether the respondent had a genuine belief that the allegations made were true. This is based on a case, North Bay Pelagic versus Anderson Arcaduces. In fact, two cases. One, North Bay Pelagic and Anderson. Then we have Arcaduces and Little in the year 2016. So let me look at it again. Let's take it slowly and try to unpick all of that. Under Section 98 of the Employment Rights Act of 1996, if an employee is dismissed, the employer must put forward a potentially fair reason for the dismissal. Otherwise, the dismissal will be unfair. So if you are working in an establishment, in an organization, and people level allegations against you and they have to dismiss you. Now, this case is saying that they will have to find a reason that is so fair for the dismissal. Now, in order for a dismissal to be substantively fair, it must fall within the range of reasonable responses in the circumstances. This means that the dismissal of the employee must be reasonable. The evaluation of its reasonableness depends on three factors: whether a fair investigation has been carried out, whether the respondent had an honest belief that the allegations made were true, whether the respondent had a genuine belief that the allegations made were true. And as I mentioned, based on two cases, North Bay Pelagic versus Anderson and Arcaduces versus Little in the year 2016. Now, Lawyer Charles Asma will be actually looking at this and explaining that to us when it is that he comes on. But I would want you to really look closely at that on unfair dismissal. Look at yourself at your workplace and the rest of it. Do you really feel that things being done against you, or if you have been asked to go away, do you think that the process has been reasonable? Do you feel that they have done things quite well, investigated, asked you to respond to those allegations and the rest of it? Lawyer Charles Asma will be leading us on that one. So think about it. If you have a question about that, you can send a text to our text number 07399 208 468. Take the number again, 07399 208 468. Or when the lines are active and you have a question about Nugget, you can also as well call in and ask. The number to call will be 0208 493 7345. Remember, the number is 0208 493 7345. So we're saying that under Section 98 of the Employment Rights Act of 1996, if an employee is dismissed, the employer must put forward a potentially fair reason for the dismissal. Otherwise, the dismissal will be unfair. Now, it goes on to say that in order for a dismissal to be substantially fair, it must fall within the range of reasonable responses in the circumstances. This means that the dismissal of the employee must be reasonable. The evaluation of its reasonableness also depends on three factors. Three of them we have listed here: whether a fair investigation has been carried out, whether the respondent has had an honest belief that the allegations made were true, and whether the respondent had a genuine belief that the allegations made were true. This will be our focus of discussion later on. But let me also bring you back before we do another round of appreciations. Let's see what it is that we are discussing this morning. Now, this afternoon, I should say. My child was born abroad and is still living abroad. Yes, you find yourself in that situation, okay? How do you successfully register this child to become a British citizen? The child is living abroad, not here in the UK. How do you do that? We shall be discussing that. And remember, we're coming your way courtesy BWF Solicitors, our trusted partners when it comes to the law. And I want to remind you that next month on the 26th of May, this has become an annual event. The Alexa Champong Foundation and Ministries is organizing funds to purchase equipment, incubators for preterm babies in deprived communities back in Ghana and Africa. And this year, they are organizing the Emmanuel Praise again in Reading, and they will be featuring Akasi Brimpon, Dinah Hamilton, and Minister OJ and Alexa Champon himself. So we are extending an invitation to you to come join us on the 26th of May 2024 when we have another round of Emmanuel Praise. We take these messages, and when we come back, Lawyer Charles Asma will get us into the discussion.
Hello. There are several questions in the community when it comes to the law, especially with immigration matters. That is why I'm inviting you to join us on the program, The Community and the Law, live on BWTV and brought to you by BWF Solicitors, our trusted partners when it comes to the law. We are going to have a very massive discussion on some of the issues of immigration matters that bother you. And they have the opportunity to meet you live on the program to explain to you all the updates that have come from the Home Office and also address your questions and concerns that you might have when it comes to the law. The Community and the Law is brought to you every Saturday between 4 p.m. and 6 p.m. UK time. We're live on all social media platforms, YouTube, Facebook, and LinkedIn, at BWF Solicitors, at BWTV, and of course, we urge you to share the program and invite others to join us. Remember, it's at 4 p.m. to 6 p.m. every Saturday, live on BWTV. You have your questions. There are answers. So join us, learn, and empower yourself on the program, The Community and the Law. So pick up the phone and dial 0208 493 7345. Or you can send a text 07950 422 780. It's The Community and the Law. My name is Oreku Frimpon, and I am your host.
Based in London, we are a dynamic award-winning firm specialising in a range of legal services. Welcome to BWF Solicitors, a trusted and experienced law firm specialising in immigration and nationality, appeals and judicial review, dispute resolution, family and matrimonial, and other family law disputes with international context. These include matters such as private child arrangement orders, contested and uncontested divorce, non-molestation for domestic violence, and financial remedy. Our childcare and family team appreciate the issues facing you at such a difficult time. Our advice is delivered in a confidential and sensitive manner. Meet Bernard Owusu, our esteemed senior partner, with over 32 years of experience and known for his expertise and dedication to serving our clients and the community. BWF Solicitors stands for integrity, respect, excellence, teamwork, diversity, inclusion, and service to the community. We provide tailored assistance specific to your case. At BWF Solicitors, every day is filled with dedication, creativity, and a commitment to finding the best solutions for our clients. Our team at BWF Solicitors is ready to assist you with all your legal needs. You can find us at the 4th floor, Anna House, 214 to 218 High Road, Seven Sisters, London, N15 4NP. Our main office line is 0208 493 7340, or our emergency line is 07712 761 884.
When you've got Akasi Brimpong, Minister OJ, Alexa Champong, and Diana Hamilton, what have you got? It can only be the return of Emmanuel Praise, brought to you by Alexa Champong Ministries. On Sunday, 26th of May, at the Pavilion, 143 to 145 Oxford Road, Reading, RG1 7UY. Doors open at 5. Tickets are £30 standard, £50 VIP, which includes your VIP seat, meet and greet and take pictures with artists, VIP snacks, water and drink, and an under 18 concession rate of £15. Get yours at alexchampong.com or call +44 744 741 7321. Emmanuel Praise with Minister OJ, Akasi Brimpong, Diana Hamilton, and Alexa Champong. You will be blessed.
Okay, welcome back. Thank you for sticking around. It's a Saturday, lovely Saturday afternoon, and I am happy to have your company. Now, we are looking at that topic that I mentioned earlier on, that if you have a child that was born abroad and still living abroad, you're looking to register this child as a British citizen. What are the criteria for doing that? How do you yourself qualify to register this child to become a British citizen? We will be looking at that. Earlier on, I mentioned that we are looking at a fair and reasonable dismissal. We'll be looking at that again. I have the quiz question that I will let you in on, so that when we get there, you would have had a sneak preview of that, and then you would have the right answer to give me. But before then, let me say thank you to the very few people that have joined us already. Tilly Duma is here. Hey, hello, Tilly. And you're asking every lovely member of the family to come on board. And my senior minister, Brawai, the class is going on. Virtually saying that we've just started, so inviting people to join. Margaret Adumensa Tilly is calling. I think she's going through the register and telling people to come on. Wumpini Adam, yes, your name is on the list. Wumpini, come on board. Margaret Adumensa has responded, good afternoon all. Good afternoon to you, Maggie. How are you? We know you're doing so very well. Free legal advice, that is what it is. And so we want you to actually join us and have that discussion. Please kindly share, comment, and like. I've told you about that, and that's been reiterated here by Tilly. Ademununkum says, good afternoon, everyone. Come on board. Let's have a discussion. Kindly share the video and invite family and friends. Thank you. Thank you, Maggie, for doing that. Nanajimai has come on board, responded, please share, share, and share. And that's the keyword here. Share, and let's get it on. If you come on board, please announce your presence. Let's know you are here. And also remember to pick up the link, share with your friends and people in your network. And remember, at the end of the year 2024, as we have done with previous years, we will be awarding the person who has had the highest number of shares. So if you want to win that, Tiliduma won that for the year 2023, and the prize was wonderful. I was envious of that myself, you know. So who is going to unseat her from the throne to win the Senior Partners Appreciation Award? We will be looking at that. The records are being kept, so definitely you would have to come on board, and let's get on there. Okay, now having acknowledged those of you on board, if you come in, I will pick that one up and let you know. And Anajima, thank you very much. Good afternoon to you, Sandra Fraser. Yes, I see you have just joined us. Good afternoon to you as well. And she's going to do her usual thing by providing all the details of BWF solicitors as it is that we have here. Okay, now let me quickly look at the nugget again. Then I'll give you a sneak preview of the quiz question and see what we can do. Under Section 98 of the Employment Rights Act 1996, if an employee is dismissed, the employer must put forward a potentially fair reason for the dismissal. Otherwise, the dismissal will be unfair. So let's look at some keywords in here. It says if an employee is dismissed, the employer must. That word must. I'll be asking lawyer about that, if it is a mandatory thing or they may do it. It says the employer must put forward a potentially fair reason for the dismissal. Otherwise, the dismissal will be unfair. In order for a dismissal to be substantively fair, then that word as well, substantively fair. The word substantively, how do we measure that? Okay, now it goes on to explain, it must fall within the range of reasonable responses in the circumstances. This means that the dismissal of the employee must be reasonable. The evaluation of its reasonableness depends on three factors. One, whether a fair investigation had been carried out. Two, whether the respondent had an honest belief that the allegations made were true. Three, whether the respondent had a genuine belief that the allegations made were true. This is based on two cases, Northblade Pelagic versus Anderson and Arcaduces versus Liddell in the year 2016. So those three factors, are they the only things that we would have to look at when we're evaluating the reasonableness of the responses? And the keywords, as I said, must and substantively fair. We'll be looking at that. We'll be asking lawyer in a moment about that. Okay, now later on in the program, there's that interesting teasing bit that I take you through. That's our quiz. And I'm going to look at the questioning that we'll be bringing you. Isaac worked for a supermarket for 10 years. Isaac was dismissed for gross misconduct because he had removed some bakery items at the end of the day and applied the waste not procedure to the bakery goods. This was on the basis that the items would have been written off and disposed of at the end of the day. So he decided to let himself and his staff buy them at a discounted rate. He complained that his conduct was minor and he shouldn't have been dismissed. So look at this. I know many of you may identify properly with this because it may have happened at where you work and all that. He worked for a supermarket. He's been working for 10 years, okay. Isaac was dismissed for gross misconduct because he had removed some bakery items at the end of the day and applied the waste not procedure to the bakery goods. So waste not procedure as well, at the end of the day, well, they were going to throw them away, but it hadn't really gone bad. So they sometimes reduce the prices for people to buy them off quickly so they don't go waste. I know people have that tactics. When a supermarket closes like 10 p.m., at between 9 and 9:30 or close to when they do not allow people to enter the supermarket anymore, they reduce the very goods that may go waste, sandwiches, drinks, a few groceries that may go off and all that. So then they reduce the prices so drastically that people run to buy them. I know that in your situation, if really you're identifying with us, you may want to say that, well, I'm a staff of the supermarket. So if these goods will go west, why don't we reduce the prices and allow staff to buy them as well? This is what he did. When he was dismissed, he complained that his conduct was minor. He didn't steal. He just reduced the prices for people to buy. And he shouldn't have been dismissed. So he lodged an appeal. Now, my question is, what is likely to be the outcome of his appeal? One, the decision to dismiss him was unfair as it was not reasonable. Two, his behavior was gross misconduct and his dismissal very fair and reasonable. The appeal would be dismissed because he stole from the business. Well, did he steal from the business? I would ask, because he said that the items would have been written off and disposed of at the end of the day. So he decided to let himself and his staff buy them at a discounted rate. So the third point, saying that the appeal would be dismissed because he stole from the business, would that hold? Would it be his behavior was gross misconduct and his dismissal fair and reasonable? The decision to dismiss him was unfair as it was not reasonable. We still haven't gone through the discussion, but let's look at the nugget again. Maybe you can relate to this. It says under Section 98 of the Employment Rights Act of 1996, if an employee is dismissed, the employer must put forward a potentially fair reason for the dismissal. Otherwise, the dismissal will be unfair. In order for the dismissal to be substantively fair, it must fall within the range of reasonable responses in the circumstances. This means that the dismissal of the employee must be reasonable. The evaluation of its reasonableness depends on three factors: whether a fair investigation had been carried out, whether the respondent had an honest belief that the allegations made were true, whether the respondent had a genuine belief that the allegations made were true. What do you think? Think about that, and we will be discussing that as well. And also get your questions and concerns ready. When we get to that point, we'll be putting them forward to Lawyer Charles Osman. The number to call will be 0208-493-7345, or you can send a text and WhatsApp message to 07399-208-468. We'll be right back.
Hello. There are several questions in the community when it comes to the law, especially with immigration matters. That is why I'm inviting you to join us on the program, The Community and the Law, live on BWTV and brought to you by BWF Solicitors, our trusted partners when it comes to the law. We are going to have a very massive discussion on some of the issues of immigration matters that bother you. And they have the opportunity to meet you live on the program to explain to you all the updates that have come from the Home Office and also address your questions and concerns that you might have when it comes to the law. The Community and the Law It's brought to you every Saturday between 4 p.m. and 6 p.m. UK time. We're live on all social media platforms, YouTube, Facebook, and LinkedIn. At BWF Solicitors, at BWTV, and of course, we urge you to share the program and invite others to join us. Remember, it's at 4 p.m. to 6 p.m. every Saturday, live on BWTV. You have your questions. There are answers. So join us, learn, and empower yourself on the program, the community, and the law. So pick up the phone and dial 0208 493 7345. Or you can send a text 07950 422 780. It's the community and the law. My name is Oreku Frimpong, and I am your host.
Based in London, we are a dynamic award-winning firm specialising in a range of legal services. Welcome to BWF Solicitors, a trusted and experienced law firm specialising in immigration and nationality, appeals and judicial review, dispute resolution, family and matrimonial, and other family law disputes with international context. These include matters such as private child arrangement orders, contested and uncontested divorce, non-molestation for domestic violence, and financial remedy. Our childcare and family team appreciate the issues facing you at such a difficult time. Our advice is delivered in a confidential and sensitive manner. Meet Bernard Owusu, our esteemed senior partner, with over 32 years of experience and known for his expertise and dedication to serving our clients and the community. BWF Solicitors stands for integrity, respect, excellence, teamwork, diversity, inclusion, and service to the community. We provide tailored assistance specific to your case. At BWF Solicitors, every day is filled with dedication, creativity, and a commitment to finding the best solutions for our clients. Our team at BWF Solicitors is ready to assist you with all your legal needs. You can find us at the 4th floor, Anna House, 214 to 218 High Road, Seven Sisters, London, N15 4NP. Our main office line is 0208 493 7340, or our emergency line is 07712 761 884.
Yes, so I have rattled on enough. Let's get to the discussion. I know you guys are ready for the quiz, and by now you would have worked it out as to what the answers would be. But let me go to the nugget again and pick it up. Unfair dismissal and reasonableness. Under Section 98 of the Employment Rights Act of 1996, if an employee is dismissed, the employer must put forward a potentially fair reason for dismissal. Otherwise, the dismissal will be unfair. In order for a dismissal to be substantively fair, it must fall within the range of reasonable responses in the circumstances. This means that the dismissal of the employee must be reasonable. So we're looking at must, substantively fair, and reasonable. Those three keywords, I believe that lawyer Asma will help us to do that. Now, the evaluation of reasonableness depends on three factors: whether a fair investigation had been carried out, whether the respondent had an honest belief that the allegations made were true, or whether the respondent had a genuine belief that the allegations made were true. Lawyer Asma, today I've tried to play your role, but that's a good test for me. Did I pass? Did I unpick the right things? And what will be your explanation? Let's have it.
Thank you very much. You passed and passed with distinction. So well done. Hello,
Thank you.
viewers and listeners. We come your way once again. So we go straight to the nugget. Today's nugget is about employment law, and it's about the right of employees. The statutory underpinning this is the Employment Right Act 1996. And there are sections. So section 95, section 94, section 98. Now, if you look at it, it will tell you that employee has a right not to be unfairly dismissed. Employee has a right not to be unfairly dismissed. If you go to section 230, subsection 1 of the same law, it will tell you who an employee is. Now, there is section 104, section 108, section 105, talking about who qualifies for this right. It says that the qualification is 2 years of working for the employer. So if you have worked with the employer for 2 years, then you have a right not to be unfairly dismissed. That means if you look at section 95 of the law, it will tell you that the dismissal should be fair in certain circumstances. Now to the nugget. Nugget takes us to section 98, which talks about the test for ascertaining whether the dismissal was fair or not. Remember, you have a right not to be unfairly dismissed, and therefore we have to assess whether the dismissal was fair or not. If it turns out that the dismissal was not fair, then you have a right in law to claim against the employer for unfair dismissal. So what is the test? We take you to 1978, a case law that came, and the case law is the case of Birchall versus British Home Store Limited. British Home Store is no longer active. It collapsed in 2016.
Yeah.
One of those retail shops in the UK that collapsed in 2016 was British Home Stores Limited. But then there was a lady who was working for this company in 1975, and the lady was dismissed for, as the employer thought, for misbehavior or for non-performance. And so the lady took the company to court, and the judgment came out in 1978. That set out the test, and the test was actually set out by Lord Denning. And this is what has become a benchmark for ascertaining whether somebody has been fairly dismissed or unfairly dismissed.
Okay.
So what is the test? There is a 3-stage test. I call it GHI. The GHI, for me, G means that you have, we're talking of the employer as has been set out, whether there has been investigation, whether there has been honest belief, and whether there has been genuine belief. We start with a genuine belief. Does the employer genuinely believe that the employee has done something wrong that warrants dismissal? So more or less, do you believe that I have done something wrong? If you believe, how do you know? So you have to confirm it. That's the honest belief.
Okay.
So the honest belief is to ascertain the genuine belief you hold. And to be able to confirm the belief, you have to investigate.
Definitely.
So first, I believe that you've done something wrong. Per evidence available, be it CCTV or whistle blowing or being caught in the act, whatever it is, I believe that you've done something wrong that warrant dismissal. That's genuine because there is factual evidence. The next thing is, do you actually believe this? Actually, so you have to test it. That's the honest belief.
So then the employee must admit that whatever is being leveled against him or her is true.
It's
and
not,
must admit it.
It's not about admission, by you proving to them that it's true.
So it could have happened, but if you are not able to prove it, it can't be true.
Then it could be hearsay or witch hunting.
Okay.
Could be anything. Could be malicious intent to just put something on that person. So the genuine belief is the first step.
Okay.
Something has happened and evidence available suggests that you did it. Okay. So how do you know yourself? You have to test it. And the test stage will be the investigation.
Okay.
So you carry out investigation to confirm that which you believe has happened. The third one is whether the investigation was reasonably conducted.
Okay.
was fairly conducted, was properly conducted. And how do you prove that the investigation was properly conducted? Per the laid down procedures of the employer.
Okay.
Every employer will have laid down procedure for investigating
the issues,
wrongdoing in the workplace, and what we call disciplinary procedure. So the code of conduct is engaged. You have to carry out a disciplinary action against the employer and the employee. So the first thing is the code of conduct has been breached, which is the genuine belief of the misconduct.
Okay.
The second one is for you to ascertain, so that you are sure that honestly, I believe that this has happened. That's the honest belief. And the third one is, how did you carry out this investigation? If the investigation was carried out wrongly, then it changes everything.
Okay. Now, in the nugget, if we could have it again, it says that must, under Section 98 of employment, if an employee is dismissed, the employer must put forward a potentially fair reason for the dismissal. Otherwise, the dismissal will be unfair. I picked out the word must. Must. Does it mean that it is compulsory for the employer to do that?
It is compulsory. So it must be a substantially fair reason. And that's the Birchall test. So apart from the 1, 2, 3, you've confirmed whatever has happened. You've carried out your own investigation and actually ascertained that it is true. Investigation follow through the laid down procedures in the workplace.
Okay.
But the question is, and so what? Should you still go ahead and dismiss? That's the potentially fair reason.
Okay.
So that if there's no potentially fair reason, you have to consider other factors. So within the Birchall test, Lord Denning says that we have to consider all the evidence in the round, all the circumstances, and confirm that apart from all this, considering everything else, is it fair for this person to be dismissed? So what will we be looking at? The length of work with that employer.
Okay.
If somebody has worked with you for, let's say, 20 years, 10 years, the Mrs. Birchall had worked for 10 years. So the court said that it will not be substantially fair for this lady to be dismissed. There could be other way of punishing her, but not to dismiss her because of the nature of the conduct. If the conduct is not something that should warrant dismissal, then find a way to punish the person. Maybe written warning and training, maybe suspension and come back, and so on and so forth. But if you don't do all this, you don't consider all that, and just say, I've done the investigation and it's true, and therefore go, it may not be substantially fair reason to dismiss.
Okay. Right. And then finally, I know it will take us to our quiz. The bit about the reasonableness test, where we can evaluate it. Investigations carried out, respondent had an honest belief, as you mentioned earlier on, and whether the respondent had a genuine belief that the allegations made were true. If all these three are not satisfied or met, could that be unreasonable?
Of course, then that will pure unreasonableness. But even if all these are present, so the first one actually, so you start with the third one, holding a genuine belief. Then you move on to carry out investigation to confirm, to make it an honest belief. Then we are saying that even if you have carried out investigation to make it an honest belief, we want to see how you carried out that investigation. If there's an anomaly in your investigation, then everything is wrong. So the anomaly could be that, for example, your investigation says that when this happens, within 1 week, do this. After that, do that. It's within the procedure. So if that happened and you didn't do anything after 1 month, then already there is procedural breach.
Okay.
Then whatever the investigation, how quality it is, the procedure itself have not been followed. So if you don't follow your procedure, should you benefit from that anomaly?
No.
You can't.
You can't.
So we are saying, so the law is saying that all the 3-tier test must be present. However, we have to consider the evidence and the circumstance in the round to ascertain whether dismissal will be better than anything else. If dismissal will not be better than anything else, then consider something else, such as suspension without or with pay, or final written warning, stage 2 or stage 3, depending on your procedure, with some training. It might be that they don't know, but if they knew and it happened, because they've been with you for all this, it's about loyalty as well, isn't it? Why don't you also be loyal? So if it is not something that is dangerously serious, let me put it that way, then it may not be substantially fair to dismiss this person or this employee. And again, you can see that 2016, a case law followed the same precedent which came under Betchel. And this is the case we have, the case of Anderson or the case of Norby. They follow the same 3-tier test. And this is what employers follow. And if you go to ACAS, ACAS will tell you that you do follow the Betchel test, you do follow the Norby test, and have you followed your own procedures? And have you also followed the ACAS procedures? ACAS gives you about 9-step procedure that you should follow in line with your own procedure. So what the employers do is that they look at what ACAS has recommended and include it in their procedure so that they tick all the boxes.
All right. Well, if you have any concern, any question, you can send that via text 07399 208-468, or you can put it in the comment section down below. We are going to get this back on when we have looked at our quiz question, and then we'll ask you the question and see if you may have a question or not. In the meantime, get ready. We're going to look at that critical discussion. Your child was born abroad and still living abroad. How do you successfully register this child to become a British citizen? Lawyer Charles Osma is here. A child born abroad. We want to look at how we can get this child registered as a British citizen. What I mean is it a case where every child born abroad to a parent here in the UK that has the ability or falls into the criteria to become a British citizen or not? Please unpick all these for us. A child born abroad.
Thank you very much, viewers and listeners, and thank you for keeping faith and waiting to turn this time. So the conversations about parents who live in the UK but have children abroad. For this particular conversation, we are focusing on fathers because the law looks at fathers who have children abroad, and the children or the child was born before 1st of July 2006. 1st of July 2006. What it means is that after 1st of July 2006, you have to consider something else. So before 1st July 2006, we know that within the British Nationality Act 1981, Section 1 tells you that the child takes after you if the child was born in the UK. Section 2 talks about, and Section 3 talks about something else. Now we are looking at a child who was not born in the UK, born abroad, lived abroad, and still living abroad. The father lives in the UK. So can this father register this child to become a British citizen? The law says yes. You can register the child to become a British citizen. So how do you prove? Because a case of evidence. I'm going to ask the producer to show us the policy guidance on this. And today we want to make it practical so that you know that if you can do this, then there's no point letting the child come before you go through that process. So the form is called Form UKF. Registration as a British citizen. Persons born to British fathers whose parents were not married. So 4 things are at play. 1, a child. So the person must be under 18. 2, actually more than 4. 2, that child was born before 1st of July 2006. 3, the child was born to a British father. A British father.
Okay.
4, this British father was not married to the mother of this child. If the father and the mother were married at the time, this will not qualify, or the child will not qualify under this application.
Would there be any particular reason why this will not qualify under this application?
So if they are married, then the child would then have to consider some other factor. The child will not be. So here we look. I don't know why the law gives so much powers. I was thinking about this. I said, what if it's the mother who was living abroad, not married to the father?
Yeah.
The law is silent on mothers. Because but it says the father. But if they were married, then the child will not be given registration. The child potentially could be given passport or automatic citizenship, depending on the circumstance.
So if, in that case, it does not deprive the child of a benefit.
It doesn't deprive the child of a benefit.
Okay.
So you see, the applications are so many, and therefore you are looking at which particular one. For example, somebody who is contemplating, should I bring the child to the UK before I register the child? Because we are told that if the child was born abroad and brought to the UK, the child can be registered to become a British citizen if the father or the mother is a British citizen or settled in the UK. But why, if there's opportunity, why should you bring the child here before you do the same thing that could have been done while the child is still abroad?
Okay.
But the catch is this: if the child was born after the 1st of July 2006, you can't do this. If the child was born before 1st of July 2006, you can do this.
Okay.
Yes.
All right. So let's go through the steps as it is.
So we have established the criteria. A child under 18, a child whose father is British, a child whose father was not married to the mother, and a child born before 1st of July 2006. Now let's look at the qualification. If you go down for me, producer. Right. So it says the requirement you must meet. Who can register? So if we go to who can register, that's page. Let's go to page 5, please. Page 5. Is that page 5? So who can register? Okay, so let's go down to the requirement. We are not interested in the waiting time. So requirement you must meet. You would have become a British citizen automatically if your mother had been married to your father. You see, that's what I was telling you.
Okay.
That if your mother was married to your father, then automatically you are a British citizen.
Okay.
But if your mother was not married to your father, what does it mean? You could be a British citizen. So if you could be a British citizen, what do? You have to ask for it. So you have to apply to get it. You have never been a British citizen yourself. Of course, if you are not a British, if you are a British citizen,
you didn't ask for it. There would be a need for it.
Yeah, go through the burden of registering you. Okay. And we go down to the options. So go down for me. Yeah, stay there. How someone became a British citizen. We go through the law. So there are different criteria. There could be somebody born before 1st January 1983. Because there are instances where adults can have the benefit of their citizenship, depending on their heritage or their parentage. So if the parent, depending on when the child was born, was a British citizen, the child can benefit from that. But today's conversation is only for children born before 1st of July 2006. So what evidence do you need? So the evidence you need will be, first, establishing that your father was British at the time of your birth.
Okay.
So what do you have to show that your father is British? The father's citizenship certificate. That is the naturalization certificate. Okay. And the father's British passport. Remember, passport is not compulsory.
Okay.
And therefore, what you need will be your citizenship certificate.
So if you have the passport, does it not cover the certificate because you have the certificate before you have a passport?
It is also possible that your father had a passport or became British after 1st of July 2006.
Okay.
But you can only stay before 1st of July 2006. That means your father was a British citizen before 1st of July 2006.
So then it's pertinent that you produce the
you have
certificate.
to produce the certificate of citizenship.
Okay.
The naturalization.
But if you have both, it's fine.
So if you have that, then potentially you would have applied for a passport, and therefore we put the two together.
Okay.
You also have to show that this is your father.
So birth certificate?
Birth certificate.
And if you want to extend it, you
want
provide
to
a DNA.
Them.
Do a DNA test and produce the result.
Okay. Remember, DNA is not compulsory. You can volunteer a DNA, but it's not compulsory. Is it advisable? I would say yes. Depending on your circumstance, you have to decide whether DNA or birth certificate. There's one case I did. So I sent the birth certificate, and they wrote back. Because the birth certificate is the new, the electronic one. So they wrote back to say if there is any other thing to confirm that. So I offered it to this man whose child application I was handling. That said, if you would volunteer to do a DNA, that will solve the problem. The man volunteered a DNA. It came, sent it to the people, and they said, Mr. Asma, thank you very much. We are now happy to progress. And they issued they ticked the box, and the child went for the registration. So DNA, not compulsory. If you can, please do it. It will offer a lot of benefits. Now, so for the father side, we know what we need. The question is there anything else to show that this is a father beyond the birth certificate? If you are the father, you have a couple of pictures with your child. So you want to prove even a better case. Bring some pictures that you have with your child, visiting your child, even the travel ticket that you have. You put all this together to show that, yes. But within the rules, you just have to show that you are the father.
Okay.
So if you bring the child birth certificate and you bring the DNA, that should suffice. Why should you go the extra mile of adding the pictures and all that?
Yeah.
Is it necessary? Is it advisable? I would say, even though it's not compulsory, it will make your case stronger. So if you have them, add it to the application. Once we put all that together, the next stage will be to put in the application itself. It used to be that we have to do paper application. It is now online, so you apply online. How much do you have to pay? How much do you think you have to pay?
The same fee as you pay for registration here in the UK, isn't it?
So the beauty of this is that it's free.
Oh,
it's free.
Okay.
So you get it for free.
So once you qualify,
the
registration doesn't demand that you pay.
Yeah, so the registration is free for this one. And there are instances where other applications, you have to pay for it, and then you could apply for fee waiver. But for this particular one, registration is free. Then it's only when you are sending your document, they have to bring it back, they have to go, then they'll say, pay X amount and £100 for admin process of getting the document together, posting it to you, and so on and so forth. So, and also when you are ready for the citizenship, because of the citizenship process, you may have to pay a token as part of the admin.
The one you used to drink a tea with.
Yes. So you can see that it's a fairly straightforward application. However, if you are not sure what you are doing, it can be complicated. But you have to tick all the boxes and make sure that at least you have met the rules.
Okay. Now, Lawyer, let me get into this scenario. There is a father living in the UK. The father is a British. He's got everything that there needs to be. He actually got to know that he has a child outside of the UK very late on. DNA is proven that. All the other qualifications are in there. This child was born later than 2006, would the father be able to register this child now that he has just realized that this is my child?
So we have to go through the test.
Mhm.
First, is this child still a child under 18?
Yeah.
Yes. Was this child born before 1st of July 2006? You said, is that
It's after 2006.
So I was going to ask you, does later mean later, as in the word, or before? Yeah. So you can see that the child was born after. So let's use the word before and after.
Okay.
If the child was born after, does the child satisfy this test?
Was born, it said before 2006.
Before 1st of July 2006. If it is
after, then doesn't qualify.
Then you cannot use this application.
Okay.
Then it might be that you have to. Then possibly, remember we said, depending on whether they were both father were married and so on and so forth, there could be something else. But for the fact that the child was born after 1st of July 2006, you cannot use this application for.
Okay, so by extension, the father and mother are not married, but it is established that the father is the father. Let me put it that way.
It is established the father is the father. After 2000, then we have to then go into the rules and look at which option will be better. Within the rules, it says that a child born in the UK. There are instances where it says a child born to a British father. Or mother, or both. Okay. So you see, or both means they are married. One of them, then we have to look at establishing the fact that this child is automatically British.
Okay.
And if the child is automatically British, you have to apply for passport overseas for the child. You don't have to register the child to become a citizen before you apply for a passport. So the circumstance will determine. So in this case, it's likely that we have to consider application for passport for the child if we're able to ascertain by the evidence and the fact that the child is automatically British.
Okay. Well, viewers, if you just joined us, we're having a discussion on having a child born outside of the UK, still living outside of the UK, and you'd want to apply for or to successfully register the child to become a British citizen. And this afternoon, as Lawyer Charles Asma has indicated, we are looking at fathers in this situation. 2006, July 2006 is key in there. But whatever it is, if you are in any doubt, I have always advised, and I'll keep advising, that speak to lawyers who know what they are doing. And one I will readily and first of all recommend is BWF Solicitors. You can speak to Lawyer Charles Asma himself directly. BWF Solicitors, 214-218 Tottenham High Road, Seven Sisters, North London, 0208 493 7340, 0208 493 7340. Or you can visit them at their office Monday to Friday between 9:30 in the morning and 6 p.m. And if you want empowerment, as we've been doing, you join us on the Community and the Law every Saturday afternoon between 4 and 6 p.m. UK time. Lawyer Charles Asma is here, and I believe that if you have any question concerning the topic we have just discussed, the studio number as it's on your screen, 0208 493 7345. Or you can put that in the comment section down below, on Facebook at BWF Solicitors, YouTube at BWF Solicitors, and on both platforms at BWTV as well. As I said, Lawyer Charles Asma is a resource person, and we're doing this courtesy BWF Solicitors. We'll take one quick break, look at what BWF Solicitors is offering us, and when we come back, the lines will be active, but we'll still continue with our discussion. Remember, the quiz is there waiting for you, and want to see who will get the answers right. It's the Community and the Law.
Based in London, we are a dynamic award-winning firm specialising in a range of legal services. Welcome to BWF Solicitors, a trusted and experienced law firm specialising in immigration and nationality, appeals and judicial review, dispute resolution, family and matrimonial, and other family law disputes with international context. These include matters such as private child arrangement orders, contested and uncontested divorce, non-molestation for domestic violence, and financial remedy. Our childcare and family team appreciate the issues facing you at such a difficult time. Our advice is delivered in a confidential and sensitive manner. Meet Bernard Owusu, our esteemed senior partner. With over 32 years of experience and known for his expertise and dedication to serving our clients and the community. BWF Solicitors stands for integrity, respect, excellence, teamwork, diversity, inclusion, and service to the community. We provide tailored assistance specific to your case. At BWF Solicitors, every day is filled with dedication, creativity, and a commitment to finding the best solutions for our clients. Our team at BWF Solicitors is ready to assist you with all your legal needs. You can find us at the 4th floor, Anna House, 214 to 218 High Road, Seven Sisters, London, N15 4NP. Our main office line is 0208 493 7340, or our emergency line is 07712 761 884.
Yes, so excited that you are still with us. Yes, let's see what comments you will have. Let's see what questions you have. Sandra Fraser, thank you very much. You have done what you do all the time, where you ask people to join us and you give the details as well. I mentioned earlier that if you have questions and you want to ask Lawyer Charles Asma directly, 07947 63 60 37. 07947 63 60 37, and you can get to him directly. I often call him the line of faith, hope and trust, definitely. Lawyer Charles Asma, let's look at the situation. You mentioned that there are things that people need to do, qualification criteria. Does it make it a straightforward application if it is that you can tick all the boxes?
Yes, it's mathematical.
Mm-hmm.
As long as 1 plus 1 is 2, you're able to evidence them, you'll be successful.
Evidence them. I've got my birth certificate. I have gone the next step, an extra, to provide a DNA. I've provided means of or evidence of communication. Would I then need collaboration from anybody, like the mother or something?
No, you don't even need WhatsApp communication.
Okay.
Those ones are just add-ons. You don't need a booster. If you want a booster, no problem.
Okay.
Yeah. So you just have to establish that this is my child. And that's
Okay.
why the birth certificate or the DNA, very vital. You also have to establish that at the time of the child's birth, you and the mother of the child were not married.
Okay.
But how do you prove that? That is not evidence per se. It's about you saying yes or no. So the one I was telling you about, they came back to ask me, Mr. Asma, can you please confirm whether at the time of the child's birth, the father was married to the mother? If the child was married to the mother, then this application will not be necessary. Then it's possible that the child might be automatically British. So they are literally telling you what to tell them.
Okay.
But then they were not married. So I said, no, at the time they were not married.
Okay.
Then they came back.
Now, at the time, we're looking at 2006. So at the time of the child's birth, if the father had indefinite leave to remain, but the child was born outside of the UK, does it fall into this category?
Okay. Producer, can you help us with the policy again?
Mm-hmm.
so that we know that we are. I like to use the marking scheme because the person making the decision will be using the marking scheme,
the guidance.
So the guidance. Who can register? Born outside the UK before 1st of July 2006, and your unmarried father was born, naturalized, or registered in the UK. So it usually shows how the father became a British citizen. Born, so actually, can you please go up? This is just giving us the general bit. British citizen, where it says how somebody. No,
Let's scroll down.
If you like, go to the guidance itself, the original, the front page, or the yeah, up again. Yeah. Okay. Registration as a British is a guide for persons born to what?
British fathers.
So what's the answer?
So if you have indefinite leave to remain,
You are not a British.
Okay. Okay.
You are a foreigner with settled status.
So what status would a child like that have? If, for instance, I have indefinite leave to remain in this country, but I have a child outside of the UK that is not living with me in the UK, what would that child be categorized?
Right, then you have to apply for the child to join you in the UK as a child to somebody, to a parent settled in the UK. So it says that present and settled in the UK. That will fall under paragraph 297 of Appendix FM. That is why you, the father, must prove that if you want the child to come and also have your settled or indefinite leave to remain status, prove that there's nobody in the life of the child or looking after the child. So responsibility. Or the serious compelling family circumstance argument will come in. So that is what will happen.
Okay. So I'm trying to extend the argument because definitely people will be having. But if you would want to call us now, the lines are active 0208 493 7345, or send a text to 07399208468, or you can send that to the comment section down below. If now I have acquired my British citizenship, this child was born after 2006, I would want the child to have my status as a British. But when the child was born, I was just settled in the UK. Does it make any difference?
So, okay. So at the time of birth, child's birth, you were settled, you had indefinite leave to remain. So the child can only, the maximum status the child could have is indefinite leave to remain.
At the time of birth?
At the time of birth. Later on, the child is still a child, but you have become a British citizen. So once you have become a British citizen, again, we are looking at, within the rule, it says that if the child is born in the UK, automatically they have British citizenship. Child born abroad, and you have, before their birth, citizenship, they will be looking to say the child was automatically
British,
a citizen.
Okay.
But if the child has, if you have your citizenship later on, then becomes a different conversation.
Okay.
By the time of the child's birth, you didn't have it, so the child cannot have it automatically. So if it is in the UK, having become settled or having attained your citizenship after the birth of the child, you then register the child to become a British citizen. So if somebody is in the UK, the child, so they have, let's say, indefinite leave to remain at the time of the child's birth, automatically the child is British. Or they have their citizenship when the child was born, automatically the child is British. But they had their indefinite leave to remain after the birth of the child. Then you have to register the child, even in the UK. The child will not be automatically a British citizen. You have to register the child to become. So the default position is always the date of birth of the child.
Okay.
At the time the child was born, what was the circumstance? and we can explore the circumstance to ascertain whether at the time of the child's birth, the parent was a British, and therefore the child could inherit that right or not.
Okay, so if we have been able to establish that the registration and or conferring of citizenship could happen outside of the UK.
It can happen outside the UK depending on the circumstance and provided the person can qualify. So from what you have said, we can then address it this way that, all right, let the child come in. And once the child arrives, we put in application for consideration by the Secretary of State. Because a child born abroad, brought into the UK, still a child, the Secretary of State have to use discretion to accept the child to be registered. So there are different aspects of the rules. And of course, all these rules are there for us to explore and make the best use of them. I have stretched that.
Okay. Well, if you just joined us, you have the chance to call in, and somebody is just putting unnecessary things on the platform. We'll get there. But Olufemi has sent in this one. Olufemi Olabanjo. He says, I have a couple of academic papers public in my field and a few citations to my profile. I'm also currently studying for my MSc degree in cybersecurity in the UK. Can I go in for the global talent visa? Well,
of course, everybody can go in for the global talent visa. It's not about the number of qualifications you have, but it's about the talent you have that matches the global status. And that's why you have to go through the processes, where it has to be even verified and all that. So, Ola, you can explore that possibly, and the evidence will be tested. You have to go through the process, then you may be successful and you will have this type of visa issued to you.
Would this fall under the shortage occupation something?
So it's within, so as part of the, no, this is not on the shortage occupation, it is standalone. So this is attracting the best brains
into the
That's
UK.
why it's called global talent.
Okay.
But how talented you are, that matches the global standard, depends on what you have to show and also the assessment that is carried out on your achievement.
Okay. All right. So if you have any question, you can put that in the comment section. We'll pick that one up. Let's say also that you can call us on 0208-493-7345. Does one qualify to apply for a provisional license for ID purposes whilst waiting for this 20-year route application outcome from the Home Office lawyer?
Okay. I know. This application is different from driving requirements. But if you don't have visa, right to remain in the UK, you are illegal, aren't you? So if you are illegal and you are driving and you are caught, what's going to happen?
Oh, you worsen your case because
exactly. So why do you put yourself in that situation? Why don't you wait? Okay, wait.
Anyway.
Yeah. So it's not a case of yes you can or you can't.
Just
may
don't
be lucky to
just
be
don't
issued,
do it. Just don't do it, because if you're
in
caught
that
in
excitement
trouble
of driving, you'll be in trouble. You maybe have the provisional license, but even provisional license, somebody has to be with you
whilst you're driving.
Let's say there's supervision whilst driving, and let's say the officers stop you to check something, and they end up checking your status. Then you tell them, I'm waiting for my visa. But at this point, you don't have it.
You don't have it, so you don't have. Well,
but again, even the DVLA will ask for your BRP or BRC, which you don't have, so they won't issue.
They will issue that. Yeah. Well, you can put in your comments as well as we continue to have the chance of putting them to Lawyer Charles as well. I'm Sadiq from London. I'm doing spousal visa application for my wife to come and join me. How much is the application fee? Is it 1,040 or 1,840?
So I'm interested in where is it. I'm doing a spousal visa application
from London
for my wife to join me. So it depends on the route the person is using to bring the spouse. We have skilled worker, we have people coming in as spouse of British citizen or settled person, and so on and so forth. So I will need extra information to be able to gauge. But in any case, if you go online and search visa application fees UK, it will give you all the list, and you go through to see the bit that applies to you.
Okay. Well, let's get your comments coming through 0208-493-7345. Dominic says, my son is not bearing my surname. Please, is it going to affect him when I'm applying for British passport for him? My status is indefinite leave to remain, and my son was born here in the UK.
So names are not compulsory in terms of whether my name and my child name must be the same. We choose to name our children after people that we want them to aspire to, and so on and so forth. And therefore, the child name should not necessarily be the father's name. Okay. So I would say no, you shouldn't worry about that at all. What you should worry about is your name as a father on the child's birth certificate.
Okay. Can a birth certificate be amended if it is realized that there was a mistake on there? For instance, if somebody did not include or put the name of the father on there, then later on realizes that, yeah, the father's name should go on there several years down the line. Can it be done?
Yes. So, yeah, that can be done. So you obviously they will ask you why now, what happened then. So they want to be sure that there's no pressure on you to bring the father on board, especially where you had a chance then, and so on and so forth. So they will give you, they will ask you certain questions, and once you clarify them to their satisfaction, they will insert the father's name on the certificate and reissue.
Okay, and that wouldn't be doubted anyway.
In terms of
when it's the correction is made, would they issue a new certificate or an amendment of the old one?
So they will usually make an amended certificate. There's inscription. I can't quote the inscription that is usually put on there, but either way, if this is a certificate issued by the registrar, then right. it should. I don't think anybody will doubt a British birth certificate, provided it becomes obvious.
Okay, but certificates from outside of the UK, that might be critical. Yeah.
They don't have to doubt, but sometimes they doubt, and that's why sometimes they will say we have done our checks, and the verification report says that this is not available in the database.
Okay. Well, keep them coming through 0208-493. The lines are active. The platform is also open for you to put anything on there. Remember, we're coming your way to see BWF solicitors, our trusted partners when it comes to the law. They deal with so many issues. They provide advice on several things, and especially those of you who are applying and using the certificate of sponsorship, you can contact BWF solicitors for expert support and advice, so you get it right and you don't fall foul of the law and lose your certificate. Remember, 4th floor, Anna House, 214-218, Tottenham High Road, 7 Sisters, North London. Let's give them our precision once again. When we come back, we still will be taking your questions. Lawyer Charles Osma is here.
Based in London, we are a dynamic award-winning firm specialising in a range of legal services. Welcome to BWF Solicitors, a trusted and experienced law firm specialising in immigration and nationality, appeals and judicial review, dispute resolution, family and matrimonial, and other family law disputes with international context. These include matters such as private child arrangement orders, contestant and uncontested divorce, non-molestation for domestic violence, and financial remedy. Our childcare and family team appreciate the issues facing you at such a difficult time. Our advice is delivered in a confidential and sensitive manner. Meet Bernard Owusu, our esteemed senior partner. With over 32 years of experience and known for his expertise and dedication to serving our clients and the community. BWF Solicitors stands for integrity, respect, excellence, teamwork, diversity, inclusion, and service to the community. We provide tailored assistance specific to your case. At BWF Solicitors, every day is filled with dedication, creativity, and a commitment to finding the best solutions for our clients. Our team at BWF Solicitors is ready to assist you with all your legal needs. You can find us at the 4th floor, Anna House, 214 to 218 High Road, Seven Sisters, London, N15 4NP. Our main office line is 0208 493 7340, or our emergency line is 07712 761 884.
When you've got Akasi Pong, Minister OJ, Alexa Champong, and Diana Hamilton, what have you got? It can only be the return of Emmanuel Praise, brought to you by Alexa Champong Ministries. On Sunday, 26th of May, at the Pavilion, 143 to 145 Oxford Road, Reading, RG1 7UY. Doors open at 5. Tickets are £30 standard, £50 VIP, which includes your VIP seat, meet and greet and take pictures with artists, VIP snacks, water and drink, and an under 18 concession rate of £15. Get yours at alexchampong.com or call +44 744 741 7321. Emmanuel Praise with Minister OJ, Akasi Pong, Diana Hamilton, and Alexa Champong. You will be blessed.
Well, thank you very much, Stills. There, thank you. We appreciate you. I have one on the platform. I'm trying to pick up that on WhatsApp and text network. Now, remember, our text and WhatsApp numbers are now the same: 07399208468, 07399208468. My 10-year was due last month. I haven't done my indefinite leave to remain yet, but my BIP expires the 31st of December 2024. Can I still do the indefinite leave to remain application?
Okay, so 10 years due last month, all right?
Mm-hmm.
You haven't done your indefinite yet, okay? BIP expiring December, okay?
Mm-hmm.
Okay, so this is the conversation we had in the course of this week. That it depends on how you went about the last leave to remain,
Okay.
2.5. But this person is on the 10-year route.
Okay.
Whether they are due or not depends on the circumstance. Because we now have the case of Afzal and the case of Iyeki, which the upper tribunal says that if you apply, that's if you make an application for extension during your last leave,
Mm-hmm.
or in the course of any of your leaves, and the extension application was put in based on paragraph 39E, which is just a shield, not a sword,
Okay.
then you cannot say that the application has stayed with the Home Office for a long time, and so even though your visa expires in December 2024, because you have counted your 10 years and it is up, you want to go in for indefinite leave to remain. So we'll look at the assessment of the facts to see whether there was a break or there was no break. So I will ask this person, one, when you were when you were making the application for extension, especially in the last 2.5 application, did the visa expire in your hand and relied on the 14 days grace period to extend it? If that happened, then you are not due for indefinite. We have to check how long it stayed in your hands for in terms of days and how long it stayed with Home Office for before the decision came. Put them together to get the total days in lieu that you have to make up for it.
Okay. Another person is saying that a midwife in Ghana wants to travel. Can you assess? Want to travel? If you could clarify, travel where?
Don't worry,
Let's assume that you want to travel to
respond.
the UK. Is there anything you can assist with?
All right. So what we assist you with is helping with your visa application. So first, look for a job in the UK. Once you have once you've gone through the process, you've secured a job, the employer will give you sponsorship letter or certificate. You use that certificate to apply for a visa. At that point, call again or send us a message again, and we'll be able to assist. So we are not into recruitment. We are only immigration lawyers, and we help with immigration applications. So if you are seeking help with recruitment or job opportunities, go on the internet, look for job opportunities in the UK in your field, then go through the process. Once you are done with that and you have your certificate of sponsorship, come back to us. We'll help you with the visa application.
Next one says, good morning. Well, it's afternoon, so don't worry. On behalf of a friend, he is an EU indefinite to remain person, married since 2018, but the wife joined him in 2020. The marriage is broken down irretrievably. He had one child with her, but divorce wasn't done. He recently met a lady in Ghana that he wants to marry. He wants to know if the new fee is going to affect him since he's an EU person. Can he bring the new wife 4 months after divorce? And can it affect the ex-wife when applying for indefinite? It's a bit winding.
Yeah, so keep it there, please. Let me start from the last one. Will it affect the ex-wife? The ex-wife's application is within Appendix EU, because it's an EU application. And therefore, if the ex-wife is able to prove that there has been a divorce, and so this is the divorce certificate, she will retain her right under the rules, and she will go through the retention of right route.
Okay.
Now we'll move on to the next one. Can I marry somebody 4 months after divorce? It's a matter of discretion. There's no law which says that if you divorce, wait for this number of days or months or years. It's a matter of common sense, really.
Okay.
I call it the common sense test. You've just come out of divorce. So naturally, you are scared of marriage, naturally. That's the natural tendency. So you take your time to find a new love. So 4 months, is it enough? Have you healed already? It's up to the caseworker. If you're using it to make an immigration application, the caseworker will be asking these questions and ascertain whether in the round it makes sense that this person can apply for a visa based on this husband who just left one marriage, entered into this one, and bringing this person on board. It's a matter of factual assessment. If the caseworker thinks that this is not too true, yeah, too true. It may be true. It may be true, but not too true. Then the caseworker will conclude that it appears that this is a marriage entered into with a view to gain immigration advantage. That is what we call sham marriage. But we don't know what the caseworker will say. So even me, you can see that I'm going through, let's put law aside, layman analysis. Out of it, again, and right away, visa. Is this marriage for visa or is for marriage?
Okay.
And once they have the inkling that is for visa, they will refuse and say, we think it is not a genuine marriage. Then you have to go and prove it in court. So how many months should you give yourself? It's up to you, really. You can marry the next day and bring your wife the next day, but it's really up to whether the application will work or not. Nobody will come and ask you, why did you divorce and remarry the next day? But somebody will question, why did you divorce, remarry the next day, and the third day you are bringing the lady in your name? Yeah, so
Well, the evidence is the name of the game, as I keep saying. So keep it coming. Well, we are going to ask you to test yourselves as to whether you really understood that. Now, let me go to the nuggets that I gave you at the start of the program, and I'm going to look at that again under Section 98 of the Employment Rights Act 1996. If an employee is dismissed, the employer must put forward a potentially fair reason for the dismissal. Otherwise, the dismissal will be unfair. In order for a dismissal to be substantially or substantively fair, it must fall within the range of reasonable responses in the circumstances. This means that the dismissal of the employee must be reasonable. The evaluation of this reasonableness depends on three factors. One lawyer was explaining that he did something that excited me. He started from the third one, so I'll start from the third one. Whether the respondent had a genuine belief that the allegations made were true, whether the respondent had an earnest belief that the allegations made were true, or whether a fair investigation had been carried out. Okay, now having looked at this, let me ask you the question. So I'll give you a scenario. Let's go to our friend who worked in the supermarket. He worked for a supermarket for 10 years. He was dismissed for gross misconduct because he had removed some bakery items at the end of the day and applied the waste not procedure to the bakery goods. This was on the basis that the items would have been written off and disposed of at the end of the day. So he decided to let himself and his staff buy them at a discounted rate. He complained that his conduct was minor and he shouldn't have been dismissed. Question is, what is the likely outcome of this appeal? One, the decision to dismiss him was unfair as it was not reasonable. His behavior was gross misconduct and his dismissal fair and reasonable. And then the appeal will be dismissed because he stole from the business. What do you think? Think about that. When we come back, I will ask for your answers. Then I'll ask Lawyer Charles Asma to help us unravel this. What will be the correct answer? We'll be right back.
Based in London, we are a dynamic award-winning firm specialising in a range of legal services. Welcome to BWF Solicitors, a trusted and experienced law firm specialising in immigration and nationality, appeals and judicial review, dispute resolution, family and matrimonial, and other family law disputes with international context. These include matters such as private child arrangement orders, contestant and uncontested divorce, non-molestation for domestic violence, and financial remedy. Our childcare and family team appreciate the issues facing you at such a difficult time. Our advice is delivered in a confidential and sensitive manner. Meet Bernard Owusu, our esteemed senior partner. With over 32 years of experience and known for his expertise and dedication to serving our clients and the community. BWF Solicitors stands for integrity, respect, excellence, teamwork, diversity, inclusion, and service to the community. We provide tailored assistance specific to your case. At BWF Solicitors, every day is filled with dedication, creativity, and a commitment to finding the best solutions for our clients. Our team at BWF Solicitors is ready to assist you with all your legal needs. You can find us at the 4th floor, Anna House, 214 to 218 High Road, Seven Sisters, London, N15 4NP. Our main office line is 0208 493 7340 or our emergency line is 07712 761 884.
Right, we're still live on BWTV. The program is The Community and the Law. So have you gone through the question? Yes, I know you have. So what answers are you giving me now? Let's see what you have brought. Let me go on to the question again. So Isaac worked for a supermarket for 10 years, was dismissed for gross misconduct because he had removed some bakery items at the end of the day and applied the waste not procedure to the bakery goods. This was on the basis that the items would have been written off and disposed of at the end of the day. So he decided to let himself and his staff buy them at discounted rates. He complained that his conduct was minor and shouldn't have been dismissed, actually. So he appealed. The decision to dismiss him was unfair as it was not reasonable. One of the things that we expect to happen. Is that correct? His behavior was gross misconduct and his dismissal fair and reasonable. Could that be correct? And then we said the appeal will be dismissed because he stole from the company or the business. What are your answers? Let's see what you brought. James Amwa says, number one, the decision to dismiss him was unfair as it was not reasonable. Well, Jamie, yes. Safumafo says, number two, his behavior was gross misconduct and his dismissal fair and reasonable. Safumafo says it's number two. Let's go on to the next one. Daniel Apia. Daniel Apia chooses number one. That says that the decision to dismiss him was unfair and it was not reasonable as well. Daniel, thank you for participating. Kwesi Jan says number three. The appeal will be dismissed because he stole from the business. Kwesi Jan says number three. So we have had a few people saying one, and a few people saying two. One person saying three. Adem Mununkum says it's number two. His behavior was gross misconduct and his dismissal fair and reasonable. So his appeal will not stand. That's what it says. Tilly Duma says number two. His behavior was gross misconduct and his dismissal fair and reasonable. Next one, Kevin Asamoah says number one. The decision to dismiss him was unfair as it was not reasonable. Kevin, thank you for participating. Who else do we have? Okay, for time, let me go to Lawyer Charles Asma again and see what we have. Lawyer, this is our question. This is our scenario.
Right. And we know that these things happen in most shops where they will say, throw the food away. If you throw it away, fine. If you eat, we'll punish you. Even if you are hungry. Go and buy
it for yourself.
Don't buy from here. Come on. You are going to throw the thing away anyway.
Yeah.
So if I can help myself.
Or reduce it and let me buy at a cheaper price.
But so we want to establish the cause of his dismissal. He took advantage of what is available, bought at a discount. And that is what anybody would do. The employer believes that this is not the right thing to do, and so you have to be dismissed.
Okay.
But is this a substantially fair reason to dismiss somebody who has worked with you for 10 years? What could be the response apart from dismissal? Couldn't the person have been suspended? Couldn't the person has been given a written warning? Couldn't the person has been told off so that they will not even remember to do that again? A lot of options were available. Is dismissal proportionate to this action? After all, it's not like shoplifting or stealing something substantial. It's just a waste thing.
You're going to throw away.
Throw away anyway, but we say waste not. So it might be that this was going to go to food bank to support charity cause. So if I'm also supporting myself, is it not me helping you to
would this be the argument that will be made at a hearing?
But at a hearing, we'll have to go through the test. Genuine belief, yes, the person has done this. Honest belief, yes, we've checked and we found out that it's true. CCTV and so on and so forth. Did you follow the process? Within the fact pattern, we don't know whether there was investigation or not.
Okay.
But let's assume that there was investigation. Then we have to look at the virtual test as to whether in the round, considering all the other circumstances, this is a fair reason to dismiss somebody who has worked with you for 10 years. Helping himself, something that you are going to throw away, is it a fair reason? And a reasonable person will say, this is harsh.
Okay.
And if it is taken to be harsh, then this will not wash in court. And so dismissal will be unfair.
Okay. So as I was saying, this week's the sanction of this did not come within the band of reasonable responses and was disproportionate. The employees, almost 10 years of good service and the low value of the goods involved had been overlooked. Employers should ensure that any disciplinary sanction is proportionate to the alleged misconduct and apply a lesser sanction, such as written warning, where appropriate. So, well, having worked for that long, it is believed that it was a bit harsh. So the the correct answer is number 1. How many did got it correct? I believe you mark it yourself. But with that, let's go over to the desk of Uncle Charles again for him to give us a quick summary, a snapshot of what we discussed as our main topic. My child was born abroad and living abroad. How do I successfully register this child to become a British citizen? Lawyer Asma.
So, in a nutshell, if the child was born abroad before 1st of July 2006, and the father of the child is British at the time of the child's birth, and the father was not married to the child's mother, then the law says that the child can be registered whilst abroad so that they have their citizenship in the country they are currently in. The citizenship ceremony will take place at the British council in that country, as would have happened in the borough council or a borough within the UK. But to be able to ensure that this has been successful, you have to meet the test. Evidence is the paternity test or the paternity evidence, birth certificate or DNA. Either of them or both of them if you so wish. So you have to show that the mother was not married to that father. How do you show? You have to state it as part of your application, and they will come back to ask for clarification. You have to confirm that. So this is where we draw the curtain on today's conversation. We believe that we've been able to assist you with knowledge especially in this area of immigration law. If any assistance is required, do not hesitate to reach out.
Definitely, I will not hesitate to reach out to Lawyer Charles Asma and to BWF solicitors for their kind gestures all over the years. Visit them on the 4th floor of the Anna House, 214-218 Tottenham High Road, Seven Sisters, North London. Remember, the number is 0208 493 7340. We've come to the end of another wonderful edition of the Community and the Law this afternoon. As you just heard, we discussed registering children born to British fathers, so to speak, outside of the UK, and how we can successfully register them to become British citizens. We have another topic for you same time next week. So I want to invite you to come. But before then, let's say thank you very much to Lawyer Charles Asma for his time and sharing his knowledge, to BWF solicitors for the kind opportunity they give us every time to come your way. And to you out there, I can't say thank you enough, because without you, we would have had a very blank program without anybody watching. So keep watching, keep sharing the page, BWF Solicitors, Facebook, YouTube, BWTV, Facebook, YouTube, and all the other social media platforms. On behalf of the production crew led by Professor Ade, Sheila Ankara, Patmo Dudu, and of course on my own behalf, I say thank you very much for watching. I would want to meet you again same time next week. Until then, be good.